Do we have the roll call?
Yes. Trailer.
Here?
Here. Sullivan.
Here.
Schwartz.
Here.
And the opening statement. It says the Property Maintenance Appeals Board. The Property Maintenance Appeals Board is a quasi-judicial board created by the City of Ames. The board's purpose is to decide appeals as provided for in the city's rental housing ordinance. As a board of the city, we welcome all testimony. We make our decisions based on the facts and evidence as allowed under city code and presented in open meeting. Testimony before the board must be given under oath or affirmation. If the proceedings become lengthy, we may ask that testimony be focused on new facts or evidence not already presented. When you are testifying, please address your remarks to the board. The Property Maintenance Appeals Board is an independent volunteer board of citizens. We are not part of the city administration. We are served in our efforts by Recording Secretary Natalie Reckemeyer, Building Official Sarah Van Meteren, Housing Inspectors Holly McDonald and Dan Thomas, and Assistant City Attorneys Vicki Failmeyer and Jane Chang. The order of proceedings for each application will be as follows. First, an oral statement summarizing the issues and procedural steps will be presented by the staff. Second, testimony and evidence will be presented by the applicant. Third, testimony may be heard from any members of the audience who wish to speak in support or in opposition of the appeal. Next, the board will give the staff and the applicants an opportunity to present concluding summaries and arguments. And finally, the board will discuss the issues and evidence and come to a decision. Next item on the list is review of board notes, and this refers to the two-page statement emailed to us by Sarah Van Meteren earlier. I hope you both got it. And we will let her address the notes.
Do you need to do approval of the minutes first?
Any questions or discussion regarding the minutes?
I motion to approve the meeting minutes from August 1st.
Second?
I second.
All in favor, say aye.
Aye.
Aye. All opposed?
Aye. Aye.
Thank you.
None opposed. The minutes are accepted. Thank you. And we are on to the review of board notes.
Okay. So I emailed you board notes. We just thought there was an opportunity to kind of clarify some language and some procedure. So we emailed some of the basics. We're going to go over a few of them here. Jane is here too to input when she feels necessary. If you have specific questions, let me know. And if we need more than this, or if this drums up a lot of questions, we can certainly schedule a meeting at a later time. So as the opening statement was read, you are a quasi-judicial board. So your decisions are fact-based. You don't get to create code. You don't get to create policy. You don't get to waive requirements or even determine if you agree or don't agree with the code. You're here to review what the code is and how we've enforced it. Do you want to add about the ramification? Like, if someone doesn't agree with the decision, they can file an appeal against the board. So I'll have Jane talk about what that looks like a little bit.
So as you announce at the end, once you make your decision, the appellant and anyone affected by the decision has 30 days from the date of filing the decision to appeal to a district court. So it could be the appellant. If the city disagrees with your decision, the city has the opportunity to appeal it as well. The district court would then look at what was conducted at the meeting and determine whether the board decision was correct, if it had exceeded its authority and so forth.
And also with that, up there we have the appellant can appeal, but anybody else can as well. The city could. A neighbor. So as you're thinking about, I think we had one on occupancy, number of bedrooms. If a neighbor really doesn't like that now there's 5 people and there were 4, they could appeal that. If they don't like that we are making someone put in a driveway, they could appeal that. So neighbors could too. So anybody affected by the decision or feels that they're affected could appeal it. So keep that in mind. I think that's why there's all of you represent different entities types of groups. So we try to keep all those in mind. Quorum. So for example, today we have 7 board members total. Quorum is based on the board seats, not seats filled. So quorum today is 4 people. You have 4 here. When you make a decision is valid if it has a majority of the quorum that is here. So if all 7 of you were here, 4 votes would needed for the vote. Yeah, for the vote to move forward. And then again, you can recommend code changes, but still cannot waive or voice opinion on the code. There is an avenue if you'd like the code to change. If you continue to see driveway appeals, let's say, and you're like, this code just really isn't working the way that we think it was intended to work, you could send the city council a letter and say, hey, we think you should revisit this and change it. So that's your right as the board. And if you get to that, we'll certainly help you. I think I've drafted some of those for people before.
That's right.
Boards previously. So that is a bit of what's on your paper. Are there any specific questions?
No.
No? Clear as mud. Okay.
Thank you.
Yeah.
Yes.
Yes, thank you.
Okay. Next item.
Okay, old business, we have no old business. New business, the appeal of the off-street paving materials at 115 South Riverside Drive.
Okay.
Would the city like to go ahead?
Yep. Oh, one thing I forgot to mention on the board stuff, we're going to have Jane or whatever attorney is representing us sit up here with you. If you ever start kind of like going off the cliff or on down some road that we're not comfortable with or we think you shouldn't be, she'll kind of direct you. So that should help us focus a little bit.
Good.
So for this appeal, it was a new rental in 2016. At that time, there are 2 paved ribbons that go up about to the front of the house, maybe a little past, and then a gravel area between that and the garage door. That gravel area was required to be paved because it's a new rental and all parking on new rentals has to be paved. I put a note up there. The date in the staff report was incorrect. I think I wrote that it had to be paved by 2022. It skipped an inspection cycle. So in 2016, they wanted it paved by August 1st of 2017. When we did the inspection in 2021, the gravel was still in place. Because it was not a new rental at that time, our inspectors missed that it should have been paved. They kind of just thought it was grandfathered in. But we're directed then to replenish the gravel because it needs to be maintained. We received a complaint from a neighbor that the gravel was being added and widened. I contacted the property manager. They stated they were replenishing the gravel as stated on their LOC. Didn't think there was an issue. And then the neighbor continued to complain. So we did an inspection and it showed that the gravel had, in our opinion, certainly been widened. And it wasn't just in the area by the garage. It extended down past the ribbons. So we asked them in an email to remove the gravel and pave the area by the garage as they had initially requested. And we asked this to be done by the next inspection, which it's due for inspection, I believe, in December, but we tried to get them done prior to it being expired. So I think they're scheduled end of October.
October 29th, yeah.
Just some photos. So the first photo is like a Google Streets view of what it was a couple years back. The ribbons, we don't see this much in Ames, but we cut sometimes Hollywood parking or ribbons, paved ribbons. It typically has the grass around it. That's pretty typical when we have it. Our understanding is that the gravel that did make its way down there was probably carry off from what's up by the garage, just moving down when vehicles left. The right picture is the widened driveway after gravel was installed this summer. And so we're saying that in that ribbon area, only the ribbons and grass should be there. And then the other area up top by the garage should be paved.
That's good. Question on the previous picture.
Mhm.
The area close to the street there, is that already paved? Because in some pictures it has gravel over it as well.
It's paved.
That is paved.
It's not gravel.
Okay, so the only area in question is the area next to the garage that is practically invisible unless you're on top of it.
Yep.
Okay.
Okay, I just said that. That's what, so after we contacted the management, they returned it to this state where the grass is still covered by gravel, but the ribbons are exposed now. So it's still wider than what we thought the driveway initially was. So we would have counted the ribbon to ribbon, the edge of the ribbon. That's the width of the driveway from what we would measure for the code. So the gravel on either side should be removed. Code sections you have in your report, we can come back if you need them. The appeal was filed because the appellant felt strict compliance is impracticable and additional time is needed to complete the work. Again, the definition of impracticable is up there for you. It's a factor circumstance that excuses a party from performing an act because while possible, it would cause extreme and unreasonable difficulty. The appellant feels that the ribbons have always had gravel, should be allowed to remain. And if we don't allow the gravel to remain, they're requesting an extension of time. In the PowerPoint, we put how the reasonable time limits. These are in our code and what we generally use for violations during our rental inspections. And your alternatives. So you can affirm our decision that it would not be impracticable to remove the gravel and pave the area that was required to be paved in 2016. You can reverse it if you find that it is impracticable to remove the gravel and pave that area. Or you can modify it. So you could find that it is not impracticable, but you could offer a time extension for compliance. So again, you can't waive it. You can't just say, oh, oops, we're going to let it go this time. That would be waiving the code requirement. You would have to find that it's impracticable or authorize the time extension. Questions?
Well, my question would be that section that is in question next to the garage, if the gravel is removed before winter, what is in place there and how safe is it? Is it just dirt?
So our requirement is that that area would be paved.
Right,
So they'd have to put concrete in.
right. It also says somewhere in the statement that the city regards the paving as a 180-day job. We're getting into fall and winter.
Yep. So typically seasonal things like paving, painting, we take into consideration time of year. And so the 180 days gets us halfway through the next year where the season would open up and be more
Right.
mendable to those.
My question is, what happens before that is paved? If we remove the gravel this fall, what's it going to be like through the winter, that area?
Probably a mess.
Right.
Yep.
Yeah.
So you could break it up. I think we talked about breaking up the motion for removing the gravel and then doing the paving. If you wanted to do that, you could allow, if you're going to say pave by next
Mm-hmm.
May, you could require gravel to be removed around the ribbons if you think that needs to be removed. You could require it all to be removed. You could put it all off and say it can all wait if you want to.
It is possible to order a partial gravel removal then?
Yep, you can split it up how you want. That would be the modification in number 3. So that's kind of just something you could do, but there's some room in there for you guys to change that.
Okay.
Is the city done with their portion? Because I want to hear from the appellants as well.
Yep.
Sounds good. If you want to move forward, I'll leave this part to you.
Yeah. Yes, come on up, present your case. Before you start, you need to be sworn in.
Okay.
It's very simple. Do you swear to tell the truth?
I do.
Go
All
ahead.
right, well, I put together a little packet here for you to review as well, kind of start sharing our side of the story, I guess.
Colleen, we're getting packets.
I'm sorry, I can't hear right now.
That's okay. We said we're getting packets at the moment from the appellant.
Okay, thank you. That's why it's quiet.
Mhm.
All right, my name is Matt Robinson. This is my request for an appeal of the existing gravel driveway with 2 ribbons of concrete at 115 South Riverside. Most of these facts have kind of already been laid out by Sarah, but I'm just going to review them quick. At the January 2021 inspection, we were told to replenish the gravel near the garage within the year. In the spring of 2021, a few pickup truck loads of gravel were added to the area in front of the garage where the potholes were present. This summer, we knew that the next inspection was coming up for 115 South Riverside, so we wanted to inspect the gravel drive. Since the replenishing gravel was a noted item and some of the potholes reappeared, we replenished the drive with a fresh coat of gravel over the entire parking area. As evidenced from attachment B, there has been gravel on the sides of the ribbon parking and in between the two ribbons since at least 2013. In an effort to comply with the code, we decided to replenish the gravel on the entire driveway, costing us a significant amount of money plus our time. Using the map view on the assessor's page, we used the measuring tool to estimate how wide the gravel should be around the ribbons. To ensure that the gravel was not expanded, you can see attachment E. Due to the contradicting noted items from the two inspection reports and receiving the notice to pave the driveway immediately after putting down the fresh gravel, it would be impracticable to remove all of the fresh gravel to pave the driveway. It was expensive to replenish the driveway, as we were told to do in 2021. And it seems very wasteful to throw all of that money and hard work away when it could be used to make other necessary repairs and updates to properties throughout town. We were simply trying to comply with the most recent citation, which was to replenish the gravel. We are constantly spending money to update our properties, and it would be impractical to waste our resources on this driveway when it was just improved, when the resources could be used elsewhere to make improvements that would help the city of Ames be a better place. We would also like to point out that during the time frame that we were asked to pave the driveway, the city of Ames had contradicting and vague interpretations of the code pertaining to the parking requirements for new rental properties. Please see the highlighted section of attachment C, where the city in June 2018 granted another property owner an exception for paved parking as long as there were 2 paved parking spots available in the garage. The property at 115 South Riverside has a 2-car garage that would accommodate this requirement. For these reasons, it would be reasonable to believe this property would qualify for the same exception, making it impractical to pave the driveway. And the rest of it, I think, is more of an opinion, so it's not really needed to be shared after hearing what Sarah had to say about, opinions and things of that sort.
So you're saying that there are 2 spaces in place right now,
There's 2 paved parking spots inside the garage. Correct.
and the garage is paved?
Correct.
Mhm. Would the city like to respond to that?
It's still, our interpretation would be that it still needs a paved driveway to those spaces. That is
So
What
we're
the
not really
zoning
dealing
code
with
would
parking spaces here, but the paved driveway.
correct.
Okay. Okay,
But in another circumstance, the 2 paved spots in the garage was sufficient for the city during that time frame that I was told to pave it. So it would be reasonable that this
Right.
property would qualify for the same.
right. Well, as of this date, the position of the city is pretty clear. And a mistaken interpretation of code by anyone concerned does not supersede code or render it invalid. The code is still there.
Okay.
Is that correct? Everyone agree with that?
Yeah, I mean, I guess I should ask, are you finished with?
Yeah, I'm all
okay.
finished. Yep, I can take a seat here.
Is there anyone else that will speak? Sounds good.
Okay. Questions, statements from the board?
From my eyes, obviously, this is an unfortunate situation, right? Like, at the end of the day, it is unfortunate that this happened.
Yes.
At the same time, if we've got an initial letter of compliance, that initial inspection coming in 2016 and says we want this paved by 2017, in my eyes, I mean, that is on the property owner. I mean, that's at the end of the day,
I
it is,
agree.
again, unfortunate,
Yeah.
but that is the responsibility of the property owner. I have rental properties myself in this town. I do not assume that the city is going to be keeping me responsible for the things they tell me to do. I believe that's my responsibility. And if I get it wrong, I believe it's my responsibility to fix it.
That's right.
I would agree with that. I do think in this situation, because it was missed by the city at one point in time, if there is concern about timing,
Mhm.
I would be inclined to consider some leniency with getting things to the state the city wants.
Yep.
Mhm.
But I also know the city generally tries to be fairly cooperative with landlords, so I would look to them to provide some guidance as to what that timing should be.
Right.
Sure. Yeah, I don't think we can get concrete down
No,
till
that is correct.
April-ish.
Yeah.
So,
Yeah, I would say March 1st, depending on weather.
Mhm.
But knowing Iowa, probably closer to April.
Yeah.
Yeah. And I think that would apply to the gravel that is in place in front of the garage right now, too. You wouldn't want to remove that. Removing the gravel next to the 2 concrete strips, I think that that certainly is allowable.
I don't think it's necessarily in the city's interests or the property owner's interest to break up these tasks. I think it makes sense to say you have a certain amount of time
Final
to complete
deadline.
all of them. Yeah.
I would agree.
So you would put off removing the gravel by the 2 strips until spring as well?
I would. I think it would
Well,
be. in our
we already
best
have
interest.
2 complaints from the neighbor, and that is the problem with gravel. That's why the city doesn't like it. Gravel is kind of like migrating birds or cats. It goes everywhere except where you want it to go.
I don't disagree. At the same time, I'm a little bit afraid of removal of gravel in those situations, effectively leaving a mud pit.
I would favor removing the gravel where the 2 concrete strips are. I don't think that would be a problem. Removing it next to the garage, I think certainly would be a problem.
Yeah.
Would that be agreeable to remove the gravel by the strips this fall?
Yeah, I did. One thing I was a little unclear of in the city's presentation of materials. So is the city only asking for the gravel to be removed on the exterior and the interior is no longer viewed as an issue, or you only want to see the ribbons going up to?
We would only want to see the ribbons. The intent of those are
Right.
to be the paved tire tracks, so there shouldn't be gravel necessary. Since the 80s, it's been prohibited to add gravel parking area in town. So really none of that gravel should be there. And so if we're removing the gravel by the garage and paving it, we would expect that there be no other gravel on the site.
And pause for a second and ask Colleen, do you have anything that you wanted to mention?
No, I mean, I agree with you that it's unfortunate that that it seems like there was a mismatch in the inspection that led the homeowner to believe that they no longer had to comply. But I agree that it was pretty clear that compliance is needed. That being said, I think we should really consider, extending, that time even, up until next summer
Mm-hmm.
to comply. If I'm understanding this correctly, that the inspection did come back in afterwards and said that it was all right to have the gravel.
Yes, when they thought that because they believed it was
Grandfathered.
grandfathered in,
Right.
they thought it was
Right, because-
gravel. Yep.
I was
Yeah,
surprised to hear that.
yeah. And so I really do, just like as you stated, it's an extremely unfortunate situation. But I do agree that there needs to be, compliance to the original code, and it's not impractical.
Well, another way to look at it, the way I frequently do, is you had 8 free years when you were supposed to pave it and it never got paved. So congratulations on 8 free years, and it's time to do it now.
Yeah, but they had to pay a lot of money to get that gravel put in and do that, and they
I know.
probably would have made a different decision if the city would have been consistent with that next, with a little bit more careful.
That is unfortunately true.
So,
And if I put my thinking hat on here, it's like every time I have an inspection about to come up, you know what I do? I go back to my previous letter of compliance and I reread it, and I
Right.
walk my property
Right.
before the inspection and make sure we've got everything taken care of. There are no surprises. I do that weeks before.
I wish
So-
everybody did that. The value of a pre-inspection is
Mhm.
very,
We always
very
do a
great.
Inspection as well, but
Mhm.
it somehow.
Yes.
cracks. So I'm not,
Sure.
Yeah.
Yeah. In the future.
It's not to do a pre-inspection before.
Of course.
So many houses, if we didn't do pre-inspections. it
No.
would
Yeah,
be
of course.
right at the
How
inspection.
many fire detectors have the tent stripped down, things like that?
Catch most of the things. Just throwing something out there real quick that I
Mhm.
just kind of thought of too, like what,
Wait, would you mind going back up to the microphone?
Yeah.
sure.
Thanks.
You're already sworn in, of course.
It just feels like there'd be some, and I don't know what the time frame would be, like a statute of limitations, so that if time did pass, that eventually you wouldn't, like, let's say this was back in 2010 instead, is there a time frame where it would
Mhm.
no longer be relevant? If there's 4 inspections that happened, at what point would it not be relevant anymore? You know, and like, what if I would have sold the property and the new property owner, I know they have to do their due diligence, but you know, if they had a letter of compliance and they look just back at the most recent one in 2021,
Yeah.
that you could say, well, okay, we need to make sure the gravel is good because, you know, you want to do your pre-inspection and make sure that everything is good. So to a certain point, like sometimes you have to move on from that one that in the newest inspection would take precedence over that previous inspection.
I don't disagree with you, but my understanding of the municipal code is that that's not something that we can.
No.
Again, we're in an unfortunate situation,
we
territory,
cannot.
right? Yeah.
And this was ordered again at the new inspection, once they
No, it
realized the
wasn't.
mistake had been made.
No, it wasn't. It was only brought up in 2016. The next inspection doesn't not until October 29th of this month.
This was because they had laid new gravel down and the
And the
neighbor,
And the neighbor complained.
Right. Oh, I see.
Yeah.
which I think at a minimum shows that the new gravel that was
Right.
laid is problematic. It's concerning to the neighborhood.
Right.
I did
As to,
provide plenty
as
of gravel in the neighborhood, though. There is a lot of
they're
gravel.
not necessarily all rentals, and those situations are different. So I don't think we should opine on why those can or cannot exist.
sure.
In this instance, I mean, I think it's a valid question around if something is missed, how long can you be held responsible for that? I think, though, that Matt makes a valid point that we are somewhat limited in what we're allowed to consider.
Right.
And so unless the city and legal tell us that there is some sort of statute of limitations, I don't know that we can consider missed years in our decision.
I've never heard of these codes having statute of limitations.
Okay, I just want to bring that up.
And also to kind of address the homeowner's question about if it were to be sold and the next owner didn't know, that's something that we actually see quite frequently with this board, and that we would definitely require that the new homeowner was in complete strict compliance, even if they were under the impression that, you know, that they didn't need to have it that way. So we really do always aim for strict code adherence, unless it's completely impracticable.
Right.
So in the interest of moving the discussion a little bit farther forward, I think this board seems like we're pretty much in agreement about
Would you
everything
like to-
except for the when,
The timing.
the timing.
The timing.
Yeah, I'm not ready to quite make the motion yet because I'm not
Okay.
sure the timing on the
All
motion.
right.
I would say that we might have a small disagreement. I don't feel strongly about this, but I think about the practicality of getting all the equipment in, doing all the work that needs done. It seems in this giant scheme of things, which is a very set of unfortunate
Mhm.
events, the one thing this board can do to make that a little less painful is to require it all to be done by the same date. So then at least you have one crew that comes in, takes it out, because you're going to,
Mm.
the same amount of
Mhm.
heavy equipment is kind of involved in both situations, right? You're going to be ripping out old stuff. You're going to need a skid
Well,
loader
is
and
there
stuff.
that much gravel to require heavy equipment? Seems to me it'd be a dump
That's
truck,
quite a
couple of
bit.
shovels.
I've dealt with some
Okay.
some gravel. That's quite a bit, I would say.
It took 4 of us about 6 hours just to take the gravel off of the ribbons by shovel. We're not going to get it out of the dirt by hand. It would take
I
a
see.
loader.
I believe, recollection is 27 ton dropped in there.
What's the city's position on that?
On what?
On leaving the gravel over the winter and doing it all together in the spring?
That's
That's
completely up to you. The
Basically
time,
what you're saying.
yeah, the time frame's up to you.
Okay.
I mean, if the board disagrees with that,
Mhm.
one way or the other, let me know. But I think that at least makes the most sense of a bad situation. It makes it
Yeah.
at least a little bit better. We can attack this,
Mhm.
in kind of a singular nature.
What do you think, Kristen?
Yeah, I agree that it seems a little fair to
Mhm.
in this situation because again, I think there were a few missed things by multiple parties
Yeah.
throughout this. But that being said, there is a neighbor who is clearly very bothered by this.
Right.
And we are still having 80-degree days in October. So it is quite possible that they could still
Mhm.
get paving done yet this season.
Most of the contractors book out pretty far, though. I don't know. That
No, I wouldn't go for paving. Gravel removal, I think, is certainly possible. Although Matt makes a good point. Colleen, what do you think?
I have to defer to those of you who do this work, like if what's practical and what's not, you know. So it sounds like from the city's perspective that they don't push things to be happening in the winter time, but it's so iffy in Iowa. So I'd have, you know, I kind of probably have to defer to you all who've done this.
What is the current timing the city has applied for compliance? Like how long?
For this one, we just said before the next inspection, which happens to be the end of this month.
Okay.
Right.
But typically, if we had a driveway on a new rental, we would give them 180 days.
Mhm.
Or sometimes even on a new rental, we'll note it and they'll get a year.
Right. Well, personally, and for the neighbor, I would like to see the gravel or the ribbons out of there and leave the gravel in the unpaved surface next to the garage for next spring. That seems to be the safest. And we do have a legitimate complaint from a neighbor.
I disagree, but not strongly.
Yeah.
Not strongly enough to.
Right.
Yeah. Not strongly enough to do that. So.
Right.
Can I speak? I guess my only concern is if you're considering removing the gravel over the ribbons, which I believe is what I'm hearing you say,
Yes.
that is a slope. Spring rains is heavy. In Iowa, they always are. And I guess I would ask you to consider all of it just being removed at the same time. If that's going to be your stance just for an erosion factor, that's going to all end up right in the city street if we are required to move the gravel this month.
Okay.
Because the gravel's been in place for 2 months, the grass underneath of it will be dead.
Would you like to approach the microphone because this is an interesting point?
Yeah.
You swear to tell the truth?
I do.
Okay. So your position is it. Oh,
Sorry, I'm Josh Nearing, the property manager.
okay.
Yep.
Your position is that if the gravel around the strip was removed, it would not, of course, just reveal grass.
I don't
What's
believe
there
so
is
at this
similar-
point. It's been down
So
for,
what would be at the top of the driveway next to the garage? In other words, dirt.
correct. Yes, I believe there
Right.
would be at this juncture, there would be dirt underneath the gravel just due to the time frame of
Okay.
how long the gravel sat there. So then my concern would just be erosion of dirt along those ribbons in the spring, heavy spring rains.
So that is
Into the
substantially the
street.
same situation as the other area next to the garage.
Yes, so if you're gonna, I would,
But on a much steeper slope.
agreed.
And
Yep.
it's on a steeper slope. That is correct.
Yep.
It's not a
So-
steep slope, but there is a slope there.
Enough for heavy spring rains that we
Right.
get to start cutting gullies and
Right.
stuff to become a
Well,
problem.
that is an interesting point. Does the city know anything
What is
about the
what is
complaint?
the
Go ahead, Colleen.
sorry. Well, so I guess, you know, what's the feedback from the property manager or homeowner? What knowing that we're going to more than likely rule that it needs to be, you know, paved or whatnot. What do they think? What would be comfortable to them?
I think that, so I don't know if you can recognize this, Colleen, that's who is just talking, and he is noting that trying to remove the gravel prior to spring could lead to runoff with spring rains.
Okay.
Were you asking about the
So then,
property manager of the property in question or the neighbor or?
if the neighbor is there, I'd want to know what they thought, or the property manager in question, what they think.
I'm
But
interested in the neighbor's
if
position
neither here nor
myself.
there, I think
Mhm.
May 1st sounds good to me.
I'm going to disagree a little bit on the neighbor's position. I think we got to stick to code. Right? Like we just have to, no matter what the neighbor thinks.
Well, the neighbor wants the gravel gone now or as soon as
So
possible.
then that would be a very strict
Right.
code.
I think it's our goal to reach code, but also in a reasonable
Right.
time frame. I mean,
Well, there's always a safety element.
Yeah.
And that's what we're talking about here.
Yeah.
With the remove the gravel now, remove it later. That's basically a safety question.
No, I mean, I completely agree. I think the erosion, just looking at the image here, I think the erosion is actually going to be awful during, he's saying spring rains. No, I give it snow. Just the snow melt. My yard is about that slope on the side, and it ruins it every winter. So if we look at 180 days, that is unfortunately April 1st. That's not enough time.
Right,
It's not late enough this season.
right.
So I guess my question would be: are we comfortable with saying, like a 8-month time frame, something like that? And are we comfortable saying all at once? Because that's kind of where I would like to
Yeah.
motion. But if we're still not feeling that, I can understand.
Well, I think everybody is in agreement that the gravel next to the two ribbons should be removed inside and outside. Is that correct?
I think we're in agreement that
Yeah.
all the gravel goes and paving occurs.
Yep.
Again, we're just figuring out timing.
Well, we're not going to pave the area inside and outside the two ribbons.
No,
It's just the
that
area
was
by the
never-
garage.
That's
So-
never been on the table.
Once the gravel on the two ribbons is removed, what's going to be done with that area? Is it going to be replanted?
If we have to pave the area in front of the garage, we will extend the driveway all the way to the street or up to the sidewalk. I mean, so we would put pave.
You're just going to pave the entire thing?
Correct. We would take the ribbons and get rid of them. If we can just have the same time, frame for everything, so we don't have to send equipment in twice.
Is that agreeable to the city?
Yes.
It is?
Yeah, the only thing I would say as you're making your motion, I would appreciate a date certain.
Okay,
So, pick a month, first of whatever month or something instead of so many days. So we're not trying to count out.
okay. Are we close to making a motion then?
Yeah, I'm thinking June 1st. Does that seem reasonable?
June 1st?
I'm comfortable
Not April
giving
1st?
them a little more, to be honest.
More?
Would a year be reasonable?
Personally, I think so. But
When would how frequently are they being inspected?
You'll probably get
More than likely a 3-year.
a 3-year letter of
Yeah, so-
compliance.
I'm not really comfortable with anything past April 1st.
I don't think
It's
you
already
could,
been gone 8 years,
but sure, but you can't.
Also,
So
it just
again,
depends on
you-
the
depending
spring.
on weather.
So
They want it.
Matt, you could make a motion. You don't all have to agree on the deadline. So if you made a motion with a specific date, then that would go up for a vote and you could discuss that and
Mhm.
see where everyone stands.
Well, I'm going to go ahead and motion
Mhm.
for the option to modify that the property owner would have to.
That would be
um,
option 3.
Yes, option 3,
Mhm.
to remove the gravel in the area in question,
Mhm.
to pave it as requested in the 2016 letter of compliance, and to have that done by June 1st.
Or to have it done by June 1st.
Yes,
Okay, not starting June 1st.
complete by June 1st.
Complete by June 1st.
I second.
All in favor?
I
Aye.
Aye.
The motion is carried.
Great.
Would you like to read that again, just for,
I didn't have it written
You
down.
need him to. She's got
you've
it.
got it, okay. So the motion is complete removal of gravel, complete pavement of that surface from the garage down to the area that is already paved next to the street by June 1st.
Well, technically, they only have to do the stuff
Yes,
by the
we
garage.
can only
Should they-
require.
Should they choose to do more, that's their decision.
Yep.
Okay,
Exactly.
all right. Okay. Any person desiring to appeal this decision, no, excuse me, the motion is declared approved. Any person desiring to appeal this decision to a court of record may do so within 30 days after the filing of this decision. Is there any other business? Board or staff comments?
No comments on our end.
All right, if everyone is in accord, the meeting will be adjourned.
Do we need to? To adjourn the
Motion
meeting?
to adjourn. Yep. Second.
I'm still working on it.
Yeah, all good.
Are we good? Do we have to vote? No.
Yeah, do we need to
Okay.
really? Yeah, do it?
These
Okay.
two help.
So everyone in favor of adjourning the motion or adjourning? Say
Say aye.
Aye.
Aye. The motion,
Aye.
the meeting is adjourned again.
Thanks.